All right, chapter 13. This is the first of three mortgage chapters on the topic of mortgages and lending. So, in this first chapter, we're going to describe provisions of the mortgage and the note. We're going to learn what those things are. We're going to explain various methods of satisfying or transferring a mortgage, including the process of foreclosure, learning what that is. So, a mortgage is a pledge of property that serves as security or collateral for a loan. It is the promise to pay. And there are two parts of a mortgage, the mortgage itself and the note. The note is in some states they use bonds. It's the same exact thing as a note or does the same exact thing as a note. Um, it's the financing instrument that lays out all the terms of repayment, the amount borrowed, what the interest rate is, etc. It's what makes the borrower personally liable for the full amount they borrow, even in the event of foreclosure. It's what allows the lender to still chase after the borrower if, after a foreclosure, there's not enough from the proceeds of that sale to pay off the loan. They could still come after the borrower for any amount that is still owed. That's what makes them personally liable. Um, the mortgage itself is the promise to pay. That's basically says, lender, lend me your money, and I promise to pay you back the money according to the terms that I agreed upon in the note. And if I fail to, you can foreclose on me to take possession of the property pledged as collateral, sell it at auction, and then use the proceeds to pay off the debts. And it's that note that allows the lender to chase after the borrower if the proceeds from the debt isn't enough to cover what they owed. Everybody got that? Understand that? Not too difficult of a concept, right?
Mm, yeah.
So let's do the highlighting now on the mortgage and the note.
Okay, got it.
All right. So the mortgagor is the borrower. They're the owner of the property, and the mortgagee, that's the lender. Hypothecation is an upper crusty sounding word. That's simply means the pledging of property as security without actually giving up the property. Mortgage is an example of hypothecation. You're pledging your property as security for a loan, but you're not giving up that property, you're living in it. So that's what hypothecation is. All right, New Jersey's a judicial foreclosure state. Um, some states use non-judicial foreclosure and they use trust deeds, which we don't use in New Jersey, to convey real estate as security for the loan. A trustee is a neutral third party that'll hold on to the deed, and they turn it over to the borrower once they paid off the loan amount, or they give it back to the lender if the borrower starts defaulting. So therefore, foreclosure's a lot more streamlined process. It can happen a lot quicker. So foreclosure using a trust deed and uh, a trustee and a trust deed is a lot easier process. New Jersey, we have judicial foreclosure. It has to go before a court. The note and states that use trust deeds use bonds. Well, a note and a bond is the same thing. It's the financing instrument. It talks about all the obligations of the borrower, and so it's executed by the borrower. They sign it at closing. It specifies the amount borrowed, the time and method of repayment. That's the term. It discusses the rate of interest, the monthly payment amount, and it's signed by all parties involved. And it's what makes the borrower personally liable for the entire debt owed, even in the event of foreclosure. So let's go over the provisions of the mortgage document. It's executed by the owner, the borrower of the property. There has to be a legal description identifying the property that's being pledged as security for the debt. It identifies the lender and the borrower so we know who the parties are. It should be signed by all of them, and it identifies the obligations of the borrower and the rights of the lender. Defaults or breach of contract is if any of the contractual obligations are not carried out in a contract. The borrower that is in default and the lender can then foreclose. Before a lender forecloses, they'll generally give the borrower 30 days to cure any defaults and get caught up. So, what are the obligations or duties of the mortgagor? Who is the borrower? Well, we all know this one. You got to repay the debt according to the terms in the note. You have to pay all the real estate taxes on the property, because if you don't pay the taxes, you could have that tax foreclosure, right? You have to maintain the property insurance in case it burns down, gets flooded, whatever. That's the security for the loan, so you gotta insure that security. It must obtain all the lender's permission before major renovations. Ooh, that's one that a lot of people are probably unaware of. We'll get back to that one in just a second. They have to maintain the property in good condition, and they must secure permission before adding a second mortgage within 30 days. If the borrower defaults on any of these terms, the lender can start the foreclosure process on them. So let's get back to this one for a second. Did you guys know about this one? That your lender can foreclose on you if you start any major renovations on your house and you didn't get their permission? Do you guys know that?
No?
Why do you suppose that that is in place? Why do you suppose a lender can foreclose on a borrower? Why do you suppose that the borrower is obligated to get their permission first before they start any major renovations on a property? Think about it for a second. You all watch these programs for Fix This and Flip That. What's the very first stage of renovation, the construction process, other than getting permits? Come on, guys, you all watch those shows, right? Where you're going to fix this and flip that, all them houses, all them programs. What's the first step that they do?
Yeah, and estimated with a contractor? I don't know.
They get all excited about this step. Demolition day. Right? So the first step when they actually start the construction is demo day, demolition. All right, so let's just take it a small step. Let's just say you're renovating the kitchen. What's the first step is they have to rip out everything that's there. They got to gut it out, right? Okay, well, if they do that and then you lose your job, is your primary thought now, geez, how am I going to how am I going to finish the kitchen? I have to finish the kitchen? Or is it, geez, I need to get another job. I need to look out for the money. I need to balance it until I get another job. Or is your primary objective, I need to finish my kitchen renovation? Hmm. Probably that takes a secondary back seat now, right? Finishing the kitchen versus, spending your money wisely and pinching the pennies so that you until you get another job, right? But let's say now then, if that's the case, what happens when if it takes a while and you're missing a lot of mortgage payments and then a lender has to foreclose on you? What's the lender getting? They're getting a property with a destroyed kitchen, a kitchen that's ripped out. Can most people get loans to buy real estate that have no kitchen? Tell you the answer to that is no. Most lenders cannot. Most borrowers cannot get a loan to buy a house that has no kitchen in it. You have to have a working stove in it. Otherwise, you're not going to get an FHA loan. Most lenders require you to have a working kitchen and a stove even in the kitchen if you were to get a loan from them. You'd need to get a construction loan or buy cash. So if that's the case, you're limiting your buyer's pool. And what does that do to the value? A house with no kitchen. Does that tremendously bring down the value of the house?
Yes.
Oh yeah. So that's why they want to make sure you get their permission before you start any demolition, any major renovation projects that may require demolition, for example, because they're going to want to know, well, let's see the plans. What are your plans here? What are you doing? And who's doing the work? And oh yeah, where are you getting the money from for this? Do you have the money in place already to finish this project? They want to make sure that you'll be able to complete it. So let's make our notes here and do our highlights as you see here on screen. And then we'll discuss all this stuff on the next slide. So you're right next to provisions for default. It's the first step in foreclosure. Acceleration clause assists the lender in foreclosure. But before this, a lis pendens is recorded in the public records. The defeasance clause ensures that when the debt's repaid, the mortgagee has no further claim on the property. That's the lender. It requires them to add another document to the public records called a satisfaction of mortgage lien when they do pay it off. And an estoppel certificate is executed by the borrower, verifying the amount that remains to be repaid and the interest rate when the lender's selling your loan to another lender. And then I had you write this down there beneath that because it's on another page, but it still doesn't say it as clearly. That a reduction certificate does the same thing as an estoppel certificate, but it's signed by the lender. So when the lender goes to sell off your loan to another lender, they're going to want you, the borrower, to verify the amount you borrowed, the interest rate, the balance. But then that investor that's purchasing it also wants the bank that's selling it to them to verify that same information. But the document they sign is called a reduction certificate. Let me know when you guys have all those highlights.
Got it.
Anyone else still writing or need a minute, or has everybody got it?
Still writing.
Okay.
Got it.
All right. Everybody good?
I'm good.
Okay. So the acceleration clause accelerates the terms of repayment. It's the first step in foreclosure when you're falling behind on your mortgage payments. It assists the lender in foreclosure, allowing them to accelerate the terms of repayment of the debt, demanding that the entire debt is due and owing immediately. Now, prior to enacting the acceleration clause, the lender would file a lis pendens in the public records when that borrower falls behind a month or two on their mortgage payments. The lis pendens is a public notice of possible future legal action called foreclosure that may be coming soon. So when you fall behind on your mortgage payments, the lender is going to be doing their collection calls, but at a point that'll stop. And that's because they enacted the acceleration clause. The only thing that they would accept at this point would be the full amount that you owe that you're behind on, not any partial amounts, because that could create an implied contract that you have some sort of an agreement with the lender to get caught up. So once you do pay off your mortgage loan and the lender has no further claim on the property, you've defeated that baby, right? You paid off that loan, you've defeated the mortgage, defeated sounds like defeasance. The defeasance clause is when you've defeated the loan and therefore the lender has no further claim on the property. It is the defeasance clause that requires the lender now to go back into the public records and add another document called a satisfaction of mortgage lien or satisfaction of lien, showing that you've satisfied the loan and there's nothing left to be repaid. And hopefully the lender doesn't forget to do it. You should really make sure that they did do that when they're supposed to, because there's humans involved and sometimes they mess up, forget to do stuff. And that could create a nightmare over for the owner in the future if they did not clear it up. I had to deal with this one time where lady was trying to sell her property. And then that's when we found out that there's still, when she bought the property years ago from that seller, that his loan was still showing outstanding on the property. No defeasance clause was ever carried out because the owner never filed or their lender never filed the satisfaction of lien in the public records. So now it showed that she had her current loan on the property and that seller's previous loan still on the property. Yeah, that took quite a while. That was a mess. That took quite a while to clean up, but she had a couple of other issues too. You know, New Jersey at the time was short on judges, and so they started pulling them out of retirement, and some of them were kind of senile too. Um, so I remember I had some issues with a senile judge. Couldn't keep track of where, who the players were in the case. But either way, the uh this lady, she had a problem because I told her, well, when you bought the property, didn't you get a title search done and you got title insurance? Oh, my attorney ordered that for me. I know he billed me for it. And I was like, okay, okay. So then contact your attorney. He should have a copy of that title insurance policy if you can't find it. Apparently he never bought it and he just pocketed the money. So he pretty much told her, "You're on your own, lady." Uh, and so I told her, "Well, next step then is to find another attorney to sue that judge or to sue your old attorney." Problem is, she couldn't get another attorney willing to sue her old attorney because he's now a New Jersey Superior Court justice. So it created a nightmare scenario that took almost 2 years for her to clear up. That was fun. All right, so the estoppel certificate, once again, is when the lender sells your loan. Before they sell your loan, probably to another bank. Most people, when they go out and they go out and get a loan to originated to purchase a property, they got to get qualified for that loan. Right? You ever hear that? You got to qualify for the loan. There's a lot of different types of loans out there. And what are these qualifications that make you qualified to get a loan or not? There's some arbitrary terms and conditions that you need to fit within. How much money you make, what your debt is, what the debt to income ratio is, what your credit scores are, what the value of the house is in relation to the market value. There's a lot of things like that. Now, who determines that? It's the lender that's giving you the loan, right? Well, how do they come up with those figures? Well, usually your local bank will write a loan out according to their qualification terms, which it's based on an investor's guidelines. These investors are other lenders that they're planning on selling the loan to after they originated it to you. So your local bank is in the business of originating loans, creating them for the purchase of real estate, with the intent of reselling those loans to get all the money back, plus some of the interest, and maybe even getting paid a servicing fee to continue rendering the billing and accounting to the borrower and the lender who owns the loan. So that's how your local banks make money. They originate loans. They get some of the interest up front so they don't have to hold on to the loan for the long term and get all the money back so that they could then write out another loan with it. And they keep rinsing and repeating the process over and over. So when you go to a bank and they're talking about you qualifying for the loan, whose qualifications are those? It's some third party that they've lined up to purchase the loan. They said, we're not buying the loan unless the borrower and the loan meet these specifications. So that local bank only originates loans to borrowers that meet those specifications. See how that works? That's lending in a nutshell there. Now, the reduction certificate, so that estoppel certificate is signed by the borrower that verifies the amount they borrowed, the interest rate, the terms of repayment, etc. When they sell that loan to that investor, they're going to want them to sign an estoppel certificate that verifies all that information. And then they're going to want the lender that's selling them that loan to also verify that information in what is known as a reduction certificate. Everybody cool on that? Everybody understand that? This is probably the best explanation of both of them in one spot here. The note is negotiable instrument that's made that may be sold by the lender. They could assign that mortgage to another lender who's going to buy it. The satisfaction of lien that's filed in the public records when you've defeated that baby, when you've paid off the loan, you've defeated the loan. The defeasance clause requires the lender to file a satisfaction of lien in the public records, and the mortgages are recorded in the public record in the county where the property is located. It establishes a priority for those liens in the event they need to be foreclosed on later on. The ones that are recorded in a public record first take priority over which ones get paid in the event there was a foreclosure. They get paid first. And that priority is set according to the date that they're recorded in the public record, with the exception of two types of loans. And what are those loans? Well, two types of liens, I should say. Taxes jump ahead of all other liens in the priority, the repayment order, and mechanics lien, the contractor's lien. That one only needs to get paid back according. That one gets recorded. It gets backdated retroactively from the date that the materials began, or when the work. When the materials were delivered or the work began, whichever occurred first. Okay. All right. So, you got everybody here with me? You all with me here?
Yes.
Yes.
All right. Let's just throw out the morning poll, get everybody on board here. Where is everybody? Come on. Answer the poll. Tell you, it's like pulling teeth sometimes. Usury. Usury is charging an illegally high rate of interest. So usury laws apply to private parties who lend. That includes seller financing. And usury laws are put in place to prevent loan sharking. So let's highlight that. Usury, the charging of an unreasonably high rate of interest is known as usury. It's illegal. It's to prevent loan sharking. Loan sharking is when they charge you go to a private lender and they charge you a lot of interest. It's to prevent loan sharking, like gangsters lending you money. If you don't pay them back this very high interest rate, they'll break your legs, that kind of thing. So that's why it's made illegal, that kind of thing. I mean, I'm sure that's the reason that they put behind it, but I'm sure that's not why exactly. But usury is charging an illegally high rate of interest. They say it's to prevent loan sharking, but is it? Because the government can really care less how much another bank charges. So if a bank, anyone that's related in any way, shape, or form to the federal government, where the depositor's money is insured by the federal government, or they're planning on reselling those loans to any agency that's related to the federal government in any way, shape, or form, well, usury laws don't apply to them. Ah, there you go. Those politicians carving out exceptions for themselves again, just like they do with that USAID, right? Mishandling our money, or having exceptions, or thinking they're above the law. And often they are. Yeah, so New Jersey real estate. In New Jersey, a seller financing, when private owners, usury laws only apply to private parties, not to any lender that's affiliated to the federal government in any way. While the seller could charge no more than 16% on their first mortgage as an interest rate, but they could charge as much as 30% when they're selling their primary residence. And that's still not considered usury. And the part that blows my mind is that there's no usury laws that apply to the lenders. If they wanted, they could charge more. Blows your mind, doesn't it? So I've got on the next slide here, I've got a little cartoon. It's from a movie, a documentary. It's about 46, 47-minute long documentary made by an economist who pretty much summed up how borrowing and lending works in a nutshell. Where do banks get their money from? What is the Federal Reserve? Does anybody know? I mean, if you've been watching the news at all with all the Doge stuff and the government under the Trump administration, they've been putting people out giving press releases every day. One of the things they tell you is a lot of people don't understand is that the Federal Reserve has nothing to do with the federal government. It sounds like it's part of the federal government, but it is not. Presidents can't tell the Federal Reserve what to do. They try to negotiate with them, but they're going to do what the hell they want. The Federal Reserve is just the central bank here in the United States that sets the interest rates and such. Their goal is supposed to be to charge as much interest as they can without disrupting the economy or putting us into the economy into a downward spiral, so they have to try to balance that out and to keep lending. Let me show you a little clip from this documentary. I believe everybody, once they reach high school age, should probably be required to watch, but here's just a clip of it about what usury is.
Interest on a loan was called usury and was subject to severe penalties, including death. Every major religion forbade usury. Most of the arguments made against the practice were moral. It was held that money's only legitimate purpose was to facilitate the exchange of real goods and services. Any form of making money from simply having money was regarded as the act of a parasite or a thief.
Wow. So look at that. Did you guys know that? It's against my religion to pay interest. Well, it still is against a couple of religions. Just look at Hasidic Jews or even Muslims. It's against their religion to pay interest. So how do they get loans to buy real estate? There's something called a shared equity mortgage, where a private investor, often their house of worship, they're the ones that would lend them the money to buy the real estate, and they have to pay it back, but it's interest free. However, that investor, they become a partner in your ownership of your house. So when you sell it years later, hopefully at a profit, you split that profit with that investor who didn't charge you any interest on that loan. That's how it works. So can you borrow more money if you're getting charged interest free? Yeah. So imputed interest. Here's another reason to get rid of the IRS. May benefit the buyer by charging a low interest rate. However, now once again, this is for private lenders, not for those affiliated with the government. These rules that they put in place. So if I'm a homeowner and I want to lend you, or if I'm a private investor and I want to lend you my money to buy real estate, if I don't charge you a high enough interest rate, the IRS can step in and impute a higher interest rate so that they could tax you accordingly to get their fair share of it. They want to get their grubby little hands in there. Yeah. So all that little money that they take from you here and there, they're always taking money, taking, so that they could sponsor drag shows in Indonesia or or give the Taliban condoms or whatever it was. You know, they spend billions of dollars on that, which is ridiculous, or millions. Now, the IRS says the lender must charge at least 9% interest rate or an amount equal to the applicable federal rate, the AFR, whichever is lower. The AFR is the cost of lending to the local banks and lenders that is set by that central bank. So if your local bank wants to make 3%, and the AFR is at 3%, they got to charge you 6% in order to make that money. It's whatever the cost of the money is to them. They do a markup on it, and then that's where they make their money. Now, this only applies to transactions of $2.8 million or less. So this is, however, with private lenders, not with banks. You know, if I wanted to lend you money, if I'm lending you less than $2.8 million, the IRS says that I cannot charge you less than 9% interest rate or whatever amounts equal to the applicable federal rate, which currently is lower than 9%. So it would be that lower rate. All right, guys, if you got, yeah, I'm not going to, let's see. Hold on 1 second. Answer here. Okay, so that's what imputed interest is. Okay, there's also no prepayment penalties allowed in New Jersey. You may want to highlight that. It's probably on exam. No prepayment penalties allowed in New Jersey. What is that? What is a prepayment penalty? Well, if you pay off a loan, say you took out a 30-year mortgage loan and you pay it off in 20 years, you pay it off sooner than anticipated, the lender cannot charge you a fee or a penalty because you paid it off sooner. Okay, that's what a prepayment penalty is. So no prepayment penalties are allowed in New Jersey. You need to know that for exams. However, in real life, let's look at this definition here. Under New Jersey law, an institutional lender, that's one that's in any way, shape, or form related to the federal government, may not impose a prepayment fee or penalty. However, private lenders can. Those are usually for commercial loans. Okay, but for exams, just study no prepayment penalties. They're not going to try to give you a trick question or a gotcha, you know. And commercial loans, yeah, they can charge prepayment penalties if you pay them off sooner. However, on your exams, if you get a question about this, are prepayment penalties allowed in New Jersey? The answer should be no. Okay. They will give you a question on it too. Everybody got that?
Yes.
Yeah.
All right. So mortgage loans on real estate, they take priority. Their priority is set according to the date that they're recorded in the public record. Why does that matter? What does the matter, the priority of loans? Well, because in the event of foreclosure, who gets paid back first at that sheriff's sale? Who gets paid back from the proceeds of that sale? Well, it goes according to their priority, and their priority is established by the date that they were recorded in the public record. This is why when you first get a loan to buy a house, your mortgage lender wants to make sure that their loan is recorded before you get any junior liens, any second loans on the property. They want to make sure there's at least a 30-day gap in between that so that they can ensure that their lien gets recorded in the first lien holder's position. All right, a subordination agreement is where your lender signs a document, a subordination agreement, agreeing to drop back in the lien position. So if they were the primary lien holder holding the first primary lien position, they signed this document agreeing to drop back in lien position behind another lender. Now, why the heck would they want to do that? Well, often this is done when that second loan isn't large enough to wipe out the first lien holder's position in the event there has to be a foreclosure. And that second lien is often used for putting money back into the property to increase its value anyway, like a home improvement loan. That's why they don't have an issue with it dropping back in the lien repayment order in that situation there. Okay, so you can see I got my my explanation of that over here. You know, sometimes to allow further financing, usually for things like home improvement loans, this loan may be much smaller than the first loan and would not wipe out the lender's interest if a smaller loan were to jump ahead of them and they need to foreclose. The home improvement loan increases the value as smaller loans, so if foreclosed, there would be money left over to pay off the original lender in the first lien position that agreed to drop back in lien repayment. Okay? So that would be a subordination agreement. The holder of the first mortgage would then drop back in priority. That's what a subordination agreement does. All right. And when all mortgage loan payments have been made and the note's been paid in full, the mortgagee, the lender, is usually required to execute a release of mortgage and file a satisfaction of mortgage in the public records, as the lender is required to do per the defeasance clause. When you've defeated the loan, the lender has to file a satisfaction of lien in the public records. Okay? This way, anyone who purchases the real estate has let's see, what is this part here? Anyone who purchases real estate that has an assumable mortgage on it may be able to assume it and agree to pay the debt. The new owner then becomes personally obligated for payment of the debt. If the mortgage is foreclosed in such a case, the court does not have to bring enough money to pay the debt in full. A deficiency judgment against both the assumer and the original borrower can be obtained for the unpaid balance. While the assignee has become responsible for the debt, the assignor retains secondary liability if the lender cannot collect the full amount owed from the assignee. So that's if somebody takes over your mortgage loan. Okay. In the past, most loans can be taken over, assigned to somebody else who just takes over your loan. So they didn't have to qualify, go to the bank, qualify for a loan, and go through the whole process of loan origination and the fees involved and all that for loan origination. They could just take over your existing loan. Wouldn't that be great? Well, you know, most FHA loans are assumable. However, most FHA and VA loans are assumable. However, older FHA and VA loans could be assumed and taken over by anybody who didn't need to qualify for the loan. Newer ones made after a certain date, the borrower who's taking over the loan has to qualify for the loan. Now, when a mortgage is being assumed or paid off, the borrower requires a statement from the mortgagee detailing the amount currently due. This reduction certificate is often and wrongly referred to as an estoppel certificate. Yeah, because it is a document that is signed by the lender to verify how much needs to be paid off. Okay, a reduction certificate deals with the lender having to pay off a loan, whether it's to get the payoff amount for a loan or when a loan is being sold, for them to verify how much is on the loan, what the interest rate is, and all that. Now, reduction certificate does the same thing as an estoppel certificate does, but it's signed by the lender who verifies the loan terms and payoff amount. So if the loan needs to, if you're selling your house, we need to get a payoff amount from the lender. Well, that's a reduction certificate from the lender that says what the balance is. Estoppel certificates are when you're trying to get the information from the borrower. All right, so here we go. Satisfaction of mortgage lien, assuming a seller's mortgage loan, and alienation clause, also known as the resale or due on sale clause in the note. So the satisfaction of mortgage lien, anytime a loan's been paid off, the lender has no further claim on the property, they're required to file a satisfaction of mortgage lien in the public records, showing the public that there's no further, the lender has no further claim on the property. They never, when you pay off a loan, they never remove the lien from the property. Once a lien is created, it's there forever. It's just that when it's been paid off, they just add another document saying that it's been satisfied, it's been paid in full. Got it? Understand? Good?
I get it.
Okay. So anytime a document is added to the public records, it's there forever. We don't remove documents from the public records. We just may update them by adding another document and adding more information to the public record. That's all it's doing. So assuming a seller's mortgage loan is when you take over someone else's loan. You're assuming it. You're assuming the responsibility for making the payments on it now. However, the primary mortgager never gives up liability to pay it back. So if you take over someone's loan and you default and fail in making your payments, well, they could still go after the person whose loan it originally was, who then assigned their payments to you. Now, an alienation is a transfer of property that we learned that as its simplest definition. And that can be done while you're alive or after you die. It can be done voluntarily or involuntarily. So now we're learning about this alienation clause in a note, in a mortgage note. It's also known as the resale or due on sale clause. That in itself can be an exam question. You know, the due on sale clause in the note is also known as the alienation clause, or the alienation clause in the note is also known as the resale or due on sale clause. And what is its purpose? Well, it says that when you transfer the ownership, the loan needs to be paid off in full, simply put. So the purpose of this is to prevent loans from being assumed, especially by a new owner if the older loan has a lower interest rate. The lenders rather you pay off this loan and go out and get a new loan, pay all those origination fees and deal with the lenders and start paying them what the current rates are. So, yeah, seems like a big gold conspiracy, right? Why would the lender care if you just take over someone else's old loan or have to go out and get your new loan at the higher interest rates that may be currently available now? It may be with a different lender, and then they'll lose out. Well, that's okay. It seems like they all collude with each other at some level. After all, there is a central bank that they all set their rates on. They're all a member of this central club called the central bank. So loans without an alienation clause can be assumed or taken over by the new owner who can just continue making the payments on those loans, rather than going out and having to qualify for and get a new loan at maybe a higher interest rate, pay a loan origination fees, etc. I mean, this could be good for somebody who's got some banged up credit, may have trouble qualifying for a loan if they could just take over a loan of the existing person, right? Also saves them money. So that's why it's beneficial for a borrower to do that, if that would be possible. And for the seller, it's beneficial because hell, they get to sell their property. For somebody who's not, who can't be too picky because they can't get a loan otherwise, they may be willing to even pay you more for your house. So alienation clause, also known as the due on sale clause in the note. Let's do the highlights on that. Just tell me when you've got all those notes so that we could then move on to the next.
Got it.
Awesome, awesome, awesome. So what is foreclosure? And how exactly does foreclosure work? Well, when the borrower defaults in any of their obligations of the mortgage, which we already went over in this chapter, this may result in foreclosure. The lender typically gives the borrower 30 days to cure any defaults. Then a lis pendens is recorded in the public record as a public notice of possible future legal action, that legal action being foreclosure against the property. So foreclosure is the legal process of a lien holder, the lender, taking ownership of a property through the court actions, which that property has been pledged as collateral for the loan. It is the first step in starting this foreclosure is enacting the acceleration clause in the note, calling the entire debt due and owing immediately. Now, the lender could ask the court to order a foreclosure sale, often known as an auction or sheriff's sale. But before a sheriff's sale can take place, all interested parties, including the renters, need to be made aware that a foreclosure is in progress. Now, this part sometimes creates a problem for an owner who's trying to get caught up on their mortgage payments to avoid foreclosure. Because those renters now, I guess, sometimes start to figure, hey, if you're not making your payments, why the hell should I make mine? And then they start to stop making their rental payments to you as the landlord, which now pretty much puts the final nail in the coffin to the fact that you're not going to be able to recover from this foreclosure. Which is why I always recommend to owners that when they are when their lender is notifying them that they are in the foreclosure process, you as the landlord can let your tenants know that if they stop making their payments, that you're going to mess up their credit. You're going to report it to their credit reporting agencies, and you're going to take them to court to get them evicted. And now they'll have an eviction on their credit rating, and that's going to mess them up. And good luck finding another place to rent then, if you want to play games with me. I'm trying to keep my property here. Now you're deciding that you don't want to pay the rent for some reason. Hey, you're still occupying my house, and it's still my house. You either get the hell out or you pay the rent. Don't be playing games with me. So you got to play hardball like that with tenants, because once they hear that you're getting foreclosed on, they start to get this start to feel entitled, like they don't need to pay you anymore or listen to you. Still your house. Then a sheriff's sale will be advertised in the local newspaper for 4 weeks and the paper in Trenton. All right. A sheriff's sale, that auction, can be delayed twice by the lender and twice by the borrower, each time for 2 weeks, for a grand total of 2 months of delays. Well, on average, how long does it take to close a loan? 2 months. That would be perfect. Depending on when the homeowner got in touch with us to help them try to sell their property to try to avoid foreclosure. Sometimes the lenders, the borrowers, the homeowners, they don't get in touch with us asking for help to help them avoid foreclosure until they already got a sheriff's sale scheduled. So we really need to know where in the point of the foreclosure are they? Is there a sheriff's sale that's been scheduled already? Or has there not been one? So that we know how much time we have to play with as far as marketing the property, trying to find a buyer. And if it's okay to, do we have enough time to get a buyer that's going to have a loan, or do we only look for cash buyers now? So that's very important to know where they are in that transaction so we could see the urgency of how quick we need to sell this property here and how we need to price it. So bidders must pay cash, at least 20% at the auction, and the balance must be paid within 10 days, at which time a sheriff's deed, known as a bargain and sale deed, is delivered to the successful bidder. The mortgagor may repay all the outstanding fees and redeem their property before the end of that 10-day period where that sheriff's deed is delivered to the auction winner, and recover their property. But after that time that deed is delivered from the sheriff to the winner of that auction, there's no further right of redemption that exists in New Jersey. At that point, you lost the property. So, can a homeowner still keep their property even if there was a sheriff's auction that already occurred? Yeah, they could pay back all the money to get caught up before that deed is delivered. So sometimes we got homeowners that we help them sell their property. If they got to us earlier on, when they started experiencing financial difficulties and falling behind in their mortgage payments, we could have probably listed their property in the MLS, trying to get them the highest price, the current market value of the property, because there wasn't an urgency yet. And we could have gotten them a lot more money than you would have gotten at a sheriff's sale. Look, we get people, sometimes they lose their houses for foreclosure when they paid off most of the loan and they don't owe much money anymore. Maybe they lost their job, or they had medical bills or whatever that put them in financial hardship where they couldn't make their mortgage payments, but they had most of the house paid off already, only a couple of payments left to go, and they get foreclosed on. It's a shame, but what happens when that occurs? Because there's not much money that was needed to be owed still to the lender. At the sheriff's auction, do they get to keep all the proceeds as profit? The answer is no. They get whatever money was owed to them. Sheriff's department gets their 10% commission and of the sale, and the homeowner gets the balance of their money back after all other debts have been paid. So they could have gotten a lot more money if they just put their property on the market a lot earlier. But sometimes when people run into financial hardships, they put their head in the sand, they hope the problem goes away, and they do nothing to address the issue right away. And they don't contact us until it's like gets down to the point that's real dire. All right, so let's do some highlights and our little notes here.
Okay.
Okay, everybody good?
1 second.
Good, okay.
Got it.
A deed in lieu of foreclosure. It means a deed instead of foreclosure. It is an alternative to foreclosure, where the borrower just signs the deed back over to the lender. The mortgagor signs the deed back over to the mortgagee. This is often known as friendly foreclosure because it's by an agreement rather than through the court system. So there's no foreclosure on your credit report. The lender takes all the risk in taking that ownership back without going through the courts, because if they did go through the court system, it would have wiped out any other liens on the property. So the disadvantage to the lender is that they may be taking the ownership with other liens attached to the property, which then they would have to pay. So if the lender manages to, if they take a deed in lieu of foreclosure, and then they manage to sell that property within 90 days, any deficiency in the money that they're able to collect that was owed, they could go to court and get a deficiency judgment to chase after that homeowner still for that deficiency. Now, it's not likely that that will happen, but it's a possibility though. So if an owner comes to us to help them sell their property, to do a short sale on it perhaps, but then they tell us, hey, listen, the bank called me and they're offering me a deed in lieu of foreclosure. They want me to sign the property back over to me. At this point, I'll explain to them, okay, well, here is what a deed in lieu of foreclosure is and what the risks are. Here's what the short sale is. And now, because I have an interest in this, I'm going to tell you to talk to your lawyer, because I make money when I sell your house. If you just sign the deed back over to the lender, I make no money. So because of that, I don't want you coming back later on saying I gave you wrong advice or bad advice. So I'm going to tell you to talk to your lawyer on this. But let me tell you, if you take a deed in lieu of foreclosure, you could contact your lender and ask them. Ask them that if I agree to sign the deed back over to you, are you going to give me a satisfaction of lien and not agree not to chase after me for any deficiency judgments? And would you put that in writing? Because they won't. Now, the other option is you could continue trying to have me sell your property. It'll be probably a short sale if you owe more money on the house than it's currently worth. And it's still subject to the lender accepting that. So I can't guarantee that any offers will come in that will be acceptable or that will close on it before a foreclosure takes place. So with a deed in lieu of foreclosure, you could definitely avoid foreclosure, but it's not going to avoid the lender chasing after you for any deficiencies. Just be aware of that. So those are the differences between the two. You're going to have to decide and weigh the risks and decide which one it is that you want to do. But have your attorney discuss it with your attorney and then go from there. Now, so we said deficiency judgment. What is a deficiency judgment? Well, deficiency is a lack of something. Okay, it's a lack of money. They didn't get paid back all the money that was owed to them. In that, if they had to sell the property at an auction, they didn't get back all the money that was owed to them. You were deficient in paying back all the money. So they could get a judgment or order from the court saying that you have to pay that shortfall. That's what a deficiency judgment is. And lastly, an REO. REO stands for real estate owned. It's real estate owned by the bank. It is a property that may have been foreclosed on, and now it's owned free and clear by the bank with no other liens or debts on it. It's a bank-owned property, free and clear by the bank. That's what an REO property is. So let's do those highlights for deed in lieu and real estate owned.
Done.
Got it.
Okay. Everybody in?
Yes.
Okay. And that pretty much concludes this chapter. However, I got a couple of very, very interesting videos here for you to watch. Because there are two parts of a mortgage, right? The mortgage and the note. What is the note?
Bond.
Well, we don't use the bonds in New Jersey. But what is the purpose? There are two parts of a mortgage. The mortgage itself, which is the promise to pay, and then we have the financing instrument, which is the note. It is what lays out all the terms of the financing, and it's what makes you personally liable for paying back the full debt that's owed. Now, it's the document that proves that you owe the bank the money. What happens if they lose it? What happens if they can't find it? If a debt collector is trying to prove that you owe them money, do they have to prove that you owe them money? What do you think?
It will be in the records, bank records.
Not what I'm asking. I'm asking if they're trying to prove if you owe the bank money, any debtor, any lender, if they want to come after you for money that they say that you owe them, do they have to prove that you owe them money?
Yes, I had to prove. Well, there's something they call like a word thing. I don't know.
Okay, well, hold on a second. So they have to prove that you owe them money only if you contest the debt. And most people that fall behind on their mortgage payments, they knew they owe the money. So when they start getting foreclosure documents in the mail, the court documents to come attend court hearings for foreclosure, they know they owe the money, so they don't even bother going most of the time. Now, a lot of times, they don't even open up the stacks of mail that they're getting from the court setting the dates for foreclosure or the requests for information. They just ignore all the court papers. They don't even open them. So if you don't go to court to contest that the lender owes you the money, the judge is just going to bang their gavel and issue a default judgment in their favor and say you owe them the money. Therefore, you can foreclose because they didn't even show us enough courtesy to come to court today. So you don't got to prove nothing. The lender doesn't have to prove nothing. However, if you did show up to court and say, Your Honor, they say I owe them money, I'd like them to prove it. Now, you don't have to go out there and try to purge yourself and say, oh, no, I don't owe them the money or anything like that. But it's not your problem. They're the one that is suing you. It's not your problem to make the case for them and supply the evidence. You're just asking for them to show the proof. That's all you're asking for. And the way you do that is by 3 little words. You're saying, Your Honor, I would like the lender to produce the note. They say I owe them money. If I owe them money, they should have a note. This is the document that you sign when they lend you the money, right? That creates that debt, that obligation, and makes me personally liable for paying it to them. I'd like to see it. Is there anything wrong with asking that question? No. But most people don't even show up to court. So, I got a couple of videos for you about this very topic here. It's quite interesting if you think about it. Now, keep in mind, these videos are from quite a while ago, where where we were having a lot of foreclosures happening. So this particular service with all these attorneys that you're seeing on here, they took down that website, so don't bother even going to that website anymore. But I'm sure if it happens again, they'll open it back up and they'll start this all over again. But here, just watch this.
All right, joining today by Peter Murphy and Terry Smiljanich. Tell us why ConsumerWarningNetwork.com got some national play this past week with an idea to helping people in foreclosures, and that is what?
That is called Produce the Note.
Is it like Show Me the Money?
Yeah, Show Me the Money, exactly. It's on our website, and it's received a lot of national attention. AP, CNN, ABC, a lot of different entities. And what it is, it's an attempt to provide some help to people that are in foreclosure,
okay,
and who are just simply trying to slow things down so that maybe they can work with the bank a little more, because the bank's not returning their calls, is not willing to work with them. They hear about these Obama plans and other plans, and they'd like to participate in them. But meanwhile, the sheriff's knocking on the door, and they're going to be foreclosed next week. Well, what we talk about on our website is the idea of a simple request to the lender who's suing you. It's saying, let me see the note. You say I owe you this money, and it's based on a note, a mortgage. Let me see the original note, not a copy of it. Let me see the original, because whoever holds that original is the one that has the right, to enforce the debt.
Well, I thought these things had been sliced and diced and chopped up and bundled and sent off to wherever.
The problem is
right?
There's still an original note somewhere. But it's been chopped up and diced and sold and resold and resold. And the banks, what it forces the mortgage lender to do is say, ooh, where is the note? And they have to go find it. And maybe sometimes they can't find it. They can still go to court and say, well, we can't find the note, but here's the proof that we have that we're the appropriate. So it's not a way to help like deadbeats or something, to just stay in a home for free.
Because if they find the note, you're still going to be foreclosed on.
You're still going to be foreclosed on. But if it buys you an extra 8 months, where you can work with the bank and try to modify, and maybe also people that have adopted the strategy, what we've seen often is that because they've taken that approach, suddenly the lender has gotten a lot more interested in returning their phone calls and working with them.
It gets them actually in dialogue with
the squeaky wheel gets the oil, and so they get a little more attention from the bank. and they're willing to maybe work with them. So it's not a magic bullet of any kind, but it is an approach that people who are in those kind of desperate straits where they're about to have their property sold out from underneath their feet, to buy some time to see if they can work something out.
And you've seen it work for people.
Oh, we've seen it work for people, and there's lawyers in other states that have told us they've adopted the strategy, and they found that courts are very receptive to it.
Show me the note.
Show me the note.
That's fascinating.
Right.
Isn't it? Here's another video on that.
Hello, I'm Angie Moreski. The important question now is how can you use the Produce the Note strategy to help you save your home? Attorney John Yanchunas is joining us today to help give you some tips on how to proceed. John, thanks for joining us.
Thank you.
Well, first question here, is this something that anybody facing foreclosure can use?
Everybody should use it. Everybody should put the lender to the task of establishing that it owns the debt that it claims that you owe to it.
Now, is there a good indicator? I noticed as I've looked through some of the mortgage foreclosure complaints that the lenders file with the court, some of them actually have these counts in them that say reestablishment of note, and then the wording is actually the mortgage note has either been lost or destroyed, and the plaintiff is unable to state the manner in which this has occurred. They're admitting that they lost or destroyed the note.
Well, obviously that's the best sign available that the lender doesn't have the note mortgage any longer.
So if you see that, or if you want to just try Produce the Note strategy, what's the first thing you should do?
Request through discovery that instrument be produced to you. Once that's served on the lawyer representing the plaintiff's lawyer has got to respond within 30 days with the document requested. If it does not, then the consumer needs to go to court and ask the court to compel the plaintiff to produce that document.
So literally a letter or a document that you send to the court, and we'll have a template on the website to help people through that process. And why is that so important to prove what?
Well, it's important to prove that the lending institution that is suing you on the note or to foreclose your home is in fact the owner of the debt. The lending institution which originated the note and mortgage, the debt, may no longer be the owner. It may have transferred it to another institution, which in turn may have transferred it to another lending institution.
In other words, they're selling the loan. Your bank sold the loan to someone else. Well, then they need to prove that you owe them money. First of all, that's going to be difficult to do because you never signed a document with them. But they can say that they bought that loan from another lender that did sign the document with you. But they're going to need to have that copy of that document. And where is that document exactly? It's in some lender's warehouse in a box somewhere that they ship off to the middle of the country where there's less likely to be natural disasters where these things can get damaged in storms. So where is it exactly? They need to produce it, or you could ask them to.
And so on and so forth.
And you should also be careful looking at the fees and penalties that they're rolling into this request. Is that right?
That can be collected like property inspection fees, late charges, but so frequently we found that some lending institutions collect sums of money which are simply made up. They're, I think, designed to increase the lender's bottom line. For instance, a foreclosure fee, a pre-bankruptcy fee.
So keep an eye on all those fees which may be unfair and unwarranted.
Absolutely. In fact, you should ask the lender for proof that that sum of money was paid.
Obviously, if you're behind in your mortgage, this is not a way to just get your house for free. What are we trying to do here?
Well, it gives the consumer leverage or buys the consumer time to work out with that lending institution a repayment plan of the arrearage or the default.
Do you think judges will be receptive to this?
Oh, absolutely. I've tried it many times. I've done it for many years. Judges expect lawyers and parties who come before them to adhere to the letter of the law.
So if I'm the homeowner and I end up before a judge, what do I say? What's my plea?
Well, what I want is the lender to produce the original note and mortgage. If they cannot, then put them to the task of establishing why they can't, and that they are in fact the owner of the note and mortgage. And of course, more importantly, or just as important, that every element of the debt that the lender claims that the consumer owes is in fact owed.
And the ultimate goal here is perhaps to get the lenders to be more receptive to negotiating fair terms so that a homeowner can actually stay in that home and keep their home.
Absolutely. The whole concept of equity, which is the principle which allows mortgages to be foreclosed, is a concept of fairness. And one of the most important principles in equity is equity abhors a forfeiture. That means that property that secures an obligation should not be forfeited unless the letter of the law has been followed.
It's a pretty big thing to lose your home, so you should fight for it.
It's the most important asset that any consumer will ever have.
Okay, John, thank you very much. We appreciate your time here today.
Thank you.
It sure is. You guys liking this so far? Here's another one about that produce the note strategy where somebody actually puts it into effect.
With so many people losing their homes, this report from 7 on Your Side can help. You could be able to freeze a foreclosure by saying 3 simple words. Michael Finney is here tonight with what they are, and Michael, why they might work for you.
Yeah, the idea is really pretty simple. The homeowner saying to the lender, produce the note. Now, that's legal shorthand for prove I owe you the money. American mortgages have been sliced and diced, bundled into complex financial vehicles, then sold around the world.
I think the note has been sold on so many times, and they've become very sloppy with their paperwork. It could be on a dumpster somewhere, for all I know.
And for all the banking and financial managers know, too. And that's becoming a safety net for homeowners. If the loan servicer can't prove they're collecting the money legally, the homeowner is off the hook, at least temporarily.
We've never seen a company produce the original note yet.
Wow.
Attorney Chris Hoyer set up this website offering consumers advice and paperwork to pursue a produce the note strategy. In Florida, the strategy is forcing lenders to stop proceedings, buying homeowners precious time.
$100 going twice.
But it has apparently never been tried here in California. Till now.
They saved our house. She's the one that works day and night, day and night, day and night on this house. See, we don't understand none of this. She's the one that did it.
That's Isabel and Richard Caparelli. This is their home, and attempting to save it, Deborah Caparelli, their daughter-in-law. A different Florida attorney helped her by email.
First, he said, have your bankruptcy attorney file an amended schedule listing this property as unsecured. Okay? Unsecured means that Saxon, the servicer, would have to stand up and say, it's secured, we have the note.
The Caparelli's attorney, Mark Voisnat, did that, allowing him to then say, produce the note. And today the Caparellis went back to court hoping to be...
The important thing there that you may not have caught is that they were asking them to prove that they said that they filed the paperwork saying that it is unsecured debt. If it's unsecured, that means that it's not secured by collateral, meaning the real estate, and that would be a way of them discharging the debt altogether for the real estate, so that they would be able to get their house free and clear. You know, even though you're hearing this messaging here saying, oh, this is not a way for you to get your house free and clear for deadbeats to get their houses free and clear and get out of paying their mortgage. Well, it is a possibility, though. So the strategy they took is they asked them to show that that it was they made the claim in court that it's not secure, it's unsecured. The mortgage is unsecured, and if that's the case, then they couldn't try to get the house as the security for the debt. So it's up to the lender now to prove that it is secured by producing the original note that they signed when they got the loan.
The first in a long line of homeowners successfully using the produce the note strategy in California.
The judge gave us more time, and it seemed that they can't find the note yet. So we got hopes, lots of hopes.
Nothing was decided today, but the note has still not been produced.
They claim they have it, but I have no proof that they have this note. And so you would think by now, it's been almost 3 months, they would have pulled out a copy if they had it.
A recent study has found those documents are being lost an astounding 40% of the time. Now, even without the note, the banks can eventually collect if they can prove they have the legal right to a note and they can have another one issued. But that takes time, and for many in foreclosure, time is needed to straighten out their financial situations.
Well, produce the note.
Produce
3
the
words.
note.
It
Yeah.
could save you some time.
Yep.
Thanks, Michael, very much.
Pretty interesting stuff, I'd say.
With so
Check out this one. I put together this. I read this story. I figured you guys would get a kick out of this. This is an interesting story from Florida. This lady used that produce the note strategy along with many other strategies because she knew the rules that the lender needs to follow. And she was able to delay her foreclosure for 25 years. So this was the longest known foreclosure in history. Excuse me. So this was the longest known foreclosure in history. So she knew her rights. She showed up at court when they sent her documents, and she would delay the court appearances as long as she could. And then when she'd finally appear to court, she'd throw out their question or request information that the lender didn't have with them. So then they had to reschedule the date. And of course, when those new dates came around, she would delay. You know, eventually this loan got sold several times by lenders onto other lenders, and they would have to start the foreclosure process from scratch all over again. She was able to delay this for 25 years doing this. The lenders referred to this as the foreclosure from hell. So here, check out this story. Patsy Campbell hadn't made a mortgage payment since 1985. And an investment group finally foreclosed on her in 2010. And when I last looked her up in 2022, she was still alive at 84 years of age. So this is the story about her. Patsy Campbell, a retired insurance saleswoman. She fought 25 years that foreclosure on her home in Florida. She'd been living there in a house in a 2-story on a half-acre, tidy middle-class neighborhood in Central Florida since 1978. Last time she made a mortgage payment was in 1985. Her foreclosure case outlasted 6 lenders and seen 7 great-grandchildren born. Campbell has been able to keep her house protected by a 105-pound pit bull named Dodger, you know, anytime they tried serving papers. Rusty Gate, she had a locked and rusty gate advising visitors to beware of that dog. She challenged her foreclosure on the grounds that her mortgage was improperly transferred between banks and federal agencies, that lawyers for the bank had waited too long to prosecute the case, that a Florida law that shields her from creditors, and that dozens of other reasons. She's met every attempt by a lender to repossess her home with multiple appeals and counteractions, burying the plaintiffs facing her under piles of paperwork. Okay, it's pretty slick. But according to the Wall Street Journal, Robert Summers, who represents the current owner of her mortgage, calls the case the foreclosure from hell, and it's every lender's nightmare. And they were able to finally foreclose on her there in 2010. Wow. How about this? Have you ever, you have to pay HOA fees and maybe even fines to HOAs. But check out this weird instance. New Jersey has a very similar law, so this thing could happen here in New Jersey too. This woman was foreclosed on by her HOA, which then buys her condo at auction for $3.25. And then sells it for $1 to the attorney who did the foreclosure, and then they split the profits. Oh, tell me something doesn't sound corrupt as hell there. Does it? It sounds corrupt to me, right? What about you? Does it sound not quite right for that to be able to happen? Hold on for 1 second. I'll be able to play for you this video. Through the website, sorry. So let me pull it up on this website and you could listen to
Okay, here's me calling.
When Patricia Quigley calls her HOA's property management company, she gets this message.
The number you dialed is not a working number.
But call from any other phone number.
Thank you for calling Access Management Group.
You're blocked.
In 2010, Quigley, upset with her HOA's billing process, decided to take a stand and refused to pay her dues, about $700 that year. But that only led to letters from Lozega and Johansson, the law firm hired to collect on the debt. And that debt had grown.
Walked in, paid him the $2,700, and when I walked out, I said, "This is all I owe, right?" "Yes."
But it wasn't all you owed.
"No."
Shortly after, she received another bill for $3,000. She called and sent letters trying to figure out why. But all Quigley says she got in return were cryptic statements, dates with amounts that didn't make any sense to her.
Then here comes the next set of letters, and now it's up to $6,400.
Turns out there were post-judgment legal fees and 18% back interest. So even after she'd paid more than $9,000, she was still somehow behind on her dues. But in 2018, she received the most shocking letter of all, an eviction notice.
You know, you lose your home. That's hard.
But sadness turned to anger when she realized the HOA had purchased her home through foreclosure for $3.24 a year before she was evicted.
So you had been living in your house for a year, but you didn't legally own your house.
No.
Quigley says not only did the HOA accept her dues payment on a house she apparently did not own, but allowed her to make another $4,600 in home loan payments before getting kicked out.
She paid a debt she did not owe.
Yes, that's for sure, and they don't have to give it back.
Attorney George Nowak has helped craft Georgia's HOA laws since the 1980s. He says Quigley's story is tragic, but it is a tragedy of her own making.
It doesn't happen
In a vacuum.
in a back room in blue smoke and mirrors.
Nowak says the HOA can't win a judgment until the homeowner owes at least $2,000. The court must perform a title search, have the foreclosure posted in the paper for a month, and the homeowner served.
They brought this on because they ignored all of the requests to pay. They didn't show up at the trial most times.
You want some more?
Quigley admits she never did go to court, not understanding the process or the stakes involved. But Phoenicia Law, a homeowner in Douglas County, did try to fight the HOA's claims against her.
When they garnished my bank account, I was unemployed.
Law owns a home in the Rosewood Community Association. She received a payment plan to catch up on her dues, but there were a few added fees she didn't understand.
I didn't know how it was stacking up. You
just knew it was a lot.
I knew it was a lot.
She disputed the bill in court, appealing to the judge for help.
These exhibits I sent to the court.
But court records say Law's dispute arrived one day too late, so the judge couldn't consider issues like this check, an HOA payment mailed in vain.
Clearly, returned the sender 7 times.
The kicker, after she lost the case, she was told to mail her settlement payment to that same address. And this time, the check didn't come back.
While it's portrayed as cold and you're taking advantage of the homeowner, it's the exact opposite. People who don't pay their assessments are having everybody else in the community subsidize them.
Georgia law fiercely protects an HOA's right to collect what is owed, but neither of these women deny their debt. What they do have a problem with is the inability to mediate and ask questions when a disagreement arises.
A lot of times, people can't afford to fight. They just have to walk away.
According to the Community Association Institute, 6 states have some type of ombudsman to help educate and facilitate these discussions. And several states require mediation before a lawsuit is filed. Georgia isn't one of them. After Quigley was evicted, the Reveal learned her HOA sold the house to an employee at the law firm involved in her foreclosure.
That really bothers me because how could that not be illegal?
According to public documents, Legacy Investment Properties, a company that didn't legally exist at the time, bought the house for $1 and a portion of the profits. The woman behind the LLC then reactivated her real estate license and sold the home to a new family.
I've never heard a story like that before.
Well, the HOA and law firm recouped their money, and the LLC likely made some.
This cat's tougher than...
Quigley ended up homeless, losing tens of thousands of dollars in equity.
The courts have said there is no legitimate reason for not paying. If you believe the association has done you wrong, then sue the association.
Pay it.
And sue the association.
That's pretty messed up, huh? Have you ever heard of somebody foreclosing on a bank?
As a foreclosure defense attorney, this is sweet justice.
Only on Wink tonight, the tables are turned. Instead of Bank of America foreclosing on a home, a homeowner has deputies foreclose on the bank.
Bank of America filed foreclosure papers on a homeowner who didn't owe a dime. They paid for their house with cash.
Renee Stoll live at the Bank of America branch on Davis Boulevard in Naples with this story you'll see only on Wink tonight.
This is about a family who fought back and won. Their foreclosure nightmare started when they bought a house in the Golden Gate Estates owned by Bank of America. Like you said, they paid cash, so they never had a mortgage. Well, Bank of America fouled it up somewhere along the lines and actually tried to foreclose on the family. And what happened today, you're just going to have to see to believe. Movers, a truck, and an armed deputy, all while a nervous homeowner stands by and waits. This is normally what you'd see when a person's being foreclosed on and their property seized by a bank. But today, it's the other way around.
They've ignored our calls, ignored our letters. Legally, this is the next step to get my clients compensated.
A Collier County judge said Bank of America had to pay Maureen Nairges and her husband's legal fees after the bank tried to foreclose on their Golden Gate Estates property, but they paid cash. The courts agreed they never had a mortgage to begin with. After more than 5 months, the bank still hadn't paid up. So the homeowner's attorney did just what the bank would do to get their money, seize their assets.
I instructed the deputy to go in and take desks, computers, copiers, filing cabinets, including cash in the drawers.
Outside the bank, several deputies stood by with movers ready to start hauling out the bank's office supplies and furniture. Inside, the homeowner's attorney was locked out of the bank manager's office by deputies, while the bank manager tried to figure out what to do.
He was visibly shaken. Having two sheriff's deputies sitting across your desk and a lawyer standing up behind them, demanding whatever assets are in the bank, it can be intimidating. But so is having your home foreclosed on when it wasn't right.
After about an hour, the bank finally cut a check.
As a foreclosure defense attorney, this is sweet justice, because this is a symptom of a larger problem.
Now, the homeowner's attorney says that he sees mistakes all the time in foreclosure court where banks do not do their due diligence, and it winds up becoming a very lengthy process for the homeowners. He says he can only think of one other time where an attorney, the deputies, and a U-Haul came to a bank before ready to seize property. That was in Tampa. As far as Bank of America, they issued a statement saying that they apologized for the wait on the payment. They issued a notice to pay from the attorney that was working on the case on their side, but they didn't know the attorney went out of business. We'll be reporting live here in Naples. Renee Stoll, Wink News now.
And I believe that's the last story I got there. But those were some interesting videos, right? Interesting cases. Have you ever heard of some of those things? Somebody foreclosing on a bank or ways to avoid foreclosure. This could be
possible to foreclose on a bank.
That's crazy, isn't it? Yeah, I mean, I guess what is foreclosure? It's trying to get paid back your debt, right? So that's the way that the lender is able to foreclose on you. But look, he got she got a judgment from a court that the bank had to pay her, and if they're not paying out, you can find if they own any assets, one of their bank branches, for example, and just go to one of them and use that judgment as an order to get paid back. And you use the sheriff's department as your enforcer, your debt collector. That's pretty interesting, to say the least. All right, so that concludes chapter 13. Let's do the key terms to review for this chapter. There's one of them, a long one, but let's do the key terms to review, chapter 13. Lender.
Mortgagee.
Mortgagor. Oh, I'm sorry, the lender.
Lender?
Yeah. Sorry,
Mortgagor is a borrower.
Well, brain fart morning, sorry. Mortgagee is the
lender.
So 11 is A, correct. Phew. I caught myself there at the beginning there. I said that and then I caught myself right away. So 11A, pledging of property as security without surrendering possession.
Hypothecation.
Hypothecation, yes. It sounds like a rich word, right? Hypothecation. Yes, that is pledging property as security for debt, but you're not giving up the property like you would with a pawn shop, right? You go to a pawn shop, you need money, you take one of your valuables there, they hold on to it and they'll lend you a portion of its value. But they're holding on to your item because if you don't come back and pay them, well, then they'll just sell it and they'll keep the proceeds to it, and that's how they make money. So unlike that happening where they're holding on to your asset, hypothecation is an example of pledging your property without actually giving it up. So 9 is B. Written pledge of real estate as security for a loan.
Mortgage.
The mortgage itself, correct. 10 is C. Property acquired by lenders. What do we call those bank-owned properties?
Real estate owned?
Yes, REO properties. 15 is D. Clause ensuring that after repayment, the lender has no claim on the property.
Defeat clause.
The defeasance clause, right? Sounds like defeated, right? So the defeasance clause. 5 is E. Borrower's statement of how much remains on the mortgage debt.
Estoppel.
Yeah, the estoppel is the one that's signed by the borrower. 7 is F. Court order that the borrower pay money lost by the lender after foreclosure.
Deficiency judgment.
Yes, 6 is G. Borrower.
Mortgagor.
The mortgagor is the borrower. Was H, correct. A clause stating that if the property is sold, the debt is immediately payable.
Alienation.
Yes, alienation clause. Because alienation is transferring of property, right? So alienation, if the property is sold, you transfer the property, the debt is immediately payable. 2 is I. Proceeding to auction foreclosed real estate. What do we call that proceeding?
Sheriff's sale.
The sheriff's sale. 18 is J. Yeah. You had a question? No? Okay. Charging higher interest than is allowed by law. I'm sorry, I didn't hear that.
Usury?
Yes, usury. 20 is K. Failure to live up to any part of a mortgage agreement.
Default?
Yeah, you're in default. You're in default of your obligations. 4 is L. Lender's statement that the debt has been repaid in full.
Satisfaction.
Yes, the satisfaction of mortgage lien. 16 is M. Personal promise to repay money similar to a note.
Bond.
A bond, correct. 3 is N. Lender's statement of how much remains on the debt.
Reduction
The reduction certificate, correct. 14 is O. Arrangement by which a mortgage holder gives up priority.
Subordination agreement?
Subordination agreement, correct. 19 is P. To seize and sell property pledged for a debt. What do we call that whole process? Foreclosure, correct. 8 is Q. A clause stating that in case of default, the whole debt is immediately payable.
Acceleration clause?
They accelerate the terms of repayment. The entire amount is now due and owing immediately. Correct. 1 is R. Document given to purchaser of foreclosed property.
Sheriff's deed.
A sheriff's deed, even though there's really nothing called a sheriff's deed, they write sheriff's deed on top of it, but that's not a type of deed. It's actually what's known as a bargain and sale deed that they just write the words sheriff's deed on top, but the type of deed is really called the bargain and sale deed. 17 is S. We'll learn about those types of deeds in chapter 19. And then a personal promise to repay a loan similar to a bond.
Note.
A note. 13 is T. And that does it for chapter 13, the first of 3 lending chapters.